And speaking of questions, I do have an email question from Sonia, and her question goes a little something like this. There's a house that's in an estate and it was put in a child's name. Now, someone else is staying in there, but not paying the utilities, and the bills are adding up. What can be done to stop the child's credit from being ruined? Ooh, Veronica, this is something that is ugly, but it does happen when we put things in children's names. That's a whole lot of problems in this question, but do your very best to try to answer as much as you can.
I would do my best. So I would say that is a loaded question, and I have lots of questions for Sonia in following up. First, I want to know is when we talk about a house being put in a child's name, has this estate gone through probate? Because if probate has happened, the probate court is not going to put a house in the child's name. More than likely, they're going to either appoint a conservator to handle the property, and the conservator is going to be the one who makes decisions about how the bills are going to get paid. If anybody is living there, are they going to be responsible for paying the rent and how much the rent is going to be? So the court would likely appoint a conservator to handle this. There may be cases where the court would allow the child's parent, if there's a living parent or a living guardian, to have custody over this property, but they're going to put an adult in charge. So if this has happened where this property is put in the child's name, I would think there has to be some adult who has the legal authority to make things happen in the right way.
Okay.
So that's my
that's one way of looking at it.
I even thought that answer was right. As a kid, you own a house.
That's right. That's right. Somebody did this to this poor baby, but that's okay. But now, BJ, I want to ask you a question since you deal a lot in personal injury law. What happens if a person dies suddenly? Say, for example, they're in an automobile accident and, suddenly there's no will in place, they didn't do any estate planning. What happens in that scenario?
Well, when somebody dies in a car accident for any reason, the wrongful death statute says who gets to bring the cause of action, but there's an estate component to any wrongful death action. I was thinking of a medical malpractice case we had where a older gentleman had a heart concern. He went to the hospital, they checked him out, he did a little bit of treatment. It looked like he was going to be getting out. They sent him to a rehab hospital. And while he was there, he had a central line in his, providing him his medications. And the nurse came in and took the central line out. We contended inappropriately, not the way you're supposed to do it. And when that happens, air gets into your system, and you might not know this, but air in a vein is a very bad thing to happen. It's like a clot, and it goes to the heart and it kills you. And that's what happened to our client's husband. But under the wrongful death statute, the surviving spouse was the person to file the wrongful death claim for the full value of her husband's life. But his estate was the proper party to recover damages for that fright and that fear and that angst while he was trying to breathe, and the pain and suffering component. So we had to have her appointed administrator of his estate because he did not have a will. So then we could pursue the wrongful death case as well as the pain and suffering claim. And then as luck would have it, or bad luck, or their bad luck would have it, these are older people. As the case progressed, she died. So then she did have a will. So we were able to then get the administrator of her estate, because the wrongful death case that was hers then becomes a proper part of her estate that then passes through her will if she has one, or through Georgia law if she doesn't. So it's kind of a convoluted mess. But we got it worked out and resolved. But that we dealt with the probate court a couple of times on that one case. We deal with them in wrongful death setting like that. And, minor's case, if you get enough money, you can't settle it unless you get probate court approval, things like that.
Well, and now in a case like that, I'm curious, what was the timeline? How long did it take you to come to a resolve?
Well, medical malpractice cases, we had the extra year of no court for COVID. But I think we got from start to finish, it was a few years, which is pretty quick for a medical malpractice case. Yeah,
and see, a lot of times people don't think about the time limits when they start getting ready to execute a will. They think it ought to be quick. So Veronica, that's an interesting question too, because a lot of people want to know, well, when mom or dad died and they had a will, can I go ahead and get this executed fairly quickly? And what happens when you start getting into the family dynamics of excluding people? Just went through this last week, had a relative to pass away. An uncle died, left everything to all of his children except one. There was a mess last weekend. You hear me? One child was completely excluded. And for whatever reason, it was what it was. So how do you handle that when it comes to family dynamics? Or what word of advice would you give, Veronica?
Well, that's the kind of stuff that happens all the time. I work with a lot of families with heirs property. And there's a lot of situations where, for example, I talked to somebody yesterday where someone had a will. She had maybe 10 or 11 children, but some of those children passed away before she did. So she only put the living children in her will. But now the children of those children who died before the mother, they're saying, why would she have left us out of this inheritance? And so now they're wanting to get back in and say, hey, auntie, uncle, we want you to include us in this estate because we know that grandmama would have wanted us to be included. And the thing is that at that point, the will is legally binding. It determines who inherits. And as long as there's no other legal right to inherit from this person that trumps the will, for example, with a spouse might be able to get around the will because they're legally entitled to receive. But if there's nothing that's going to trump that will, then that will is going to dictate. And basically what you're left with is just unhappy family members. In some cases, like this one, perhaps the family might decide, well, we know that these are still our family. We're going to include them, but that's going to have to be an affirmative act by those who did receive from the estate to decide to include others later on.
Okay. I was just wondering.
Always be nice to your rich relatives.
Always.
Yeah,
or at least those that you don't have a will.